To me, attorney-client privilege is somewhat sacrosanct. The United States Supreme Court, in my understanding, has ruled that it survives the death of the client, it survives the attorney leaving the firm, it survives all kinds of what-ifs later. It's forever. And that's the United States Supreme Court has said that. So what we're asking for is parity on attorney-client privilege. I also liken it to the patient-provider confidentiality in healthcare.
You're not individual.
Hey, let her speak.
I'm no longer a healthcare provider, but I still do not reveal personal information about people that I worked with. And it's distracting when people yell because I lose my train of thought.
Train your concentration camp.
No, one more time and you'll be excluded. She gets a right to speak just like you did.
Commissioner Fish's example of Superfund is a really good one, in that it's quite likely that it won't be resolved within 25 years and that privileged communications between counsel and attorneys would then be available to the public and to other parties in the conflict. So the natural conclusion, if there's, until and unless we can get clarification from the legislature, is that attorney-client advice to the counsel will become oral only. There will be no documentation of it in case that could then be used against the city in future cases. And as a council member who's not likely to be on for the next 25 years, I want to be able to ask my attorney, our attorney, the council's attorney, for the advice that they gave to previous councils and to have some record of it. It's going to be really difficult for future councils if there's no record, because that advice might have been so sensitive that it wasn't written down. So I think it's an important clarification that needs to be asked. I believe there is a conflict between the different state statutes, and it's reasonable for us to ask for that clarification. Hi.
Yes. Commissioner Fritz, that was such a succinct and thoughtful statement. I'm loath to add to it, but I'll just add one point. Someone who testified admonished us not to dictate somehow the outcome of this. Let's be clear. The procedure has been established by the legislature, and this is how it works. If there's a disagreement about a public record, it goes to the district attorney, who, based on limited submissions from the party, makes his or her best ruling. The law says that if either party, the citizen or the government, think the district attorney, who last I checked doesn't fall within the zone of infallible, got it wrong, either party has the right to go to an impartial judge. Mr. Walsh, you of all people, it seems to me, would be celebrating the fact that impartial judges decide.
Don't use my name unless you're going to allow me. Let me go. Let me answer this.
Speaking, you're not.
Don't use my name.
He was talking to Joe Walsh.
We should celebrate having independent judges decide these questions, because that's the very issue we'll take up later today about a judge's ruling. So what we have been asked to do by our attorneys is to ask a judge, an impartial judge, based on the information from both sides, to tell us clearly whether we are required to turn over documents, sensitive documents covered by an attorney-client privilege after 25 years. It's a very narrow question. And if a court disagrees with our view of this, I think we should take it up with the legislature, and for the very reason Commissioner Fritz alluded to, and that is Superfund. And I think it would be substantially prejudicial to the public interest for us to turn over confidential opinions from our attorneys about liability and strategy in Superfund, which the polluters in that case, that are perfectly happy to stick us with all the liability to use against us in that instance. And I regret that people don't sort of embrace the obvious logic of that, but I think it's worthy of having an independent judge tell us yea or nay. And I think it's entirely appropriate, and it's exactly what the law contemplates. So I vote aye.
Saltzman?
Well, I appreciate this discussion. I have a lot of respect for our district attorney, Rod Underhill, but I do believe, given this discussion, we have a valid issue to appeal for an impartial opinion. Aye.
Okay.
I agree with all the policy arguments that my colleagues have made, and I respect the city attorney's office, and I signed on considering this matter today. But I have to say, just looking at the statutory language, which where 495 says, notwithstanding ORS 501 to 505, and it's 502 that exempts public records or information, the disclosure of which is prohibited, restricted, or otherwise made confidential or privileged under Oregon law. I just don't see a way around this, and I think that the law should be changed to make it clear that attorney-client privilege is attorney-client privilege. But given the law as it currently reads, I vote no.
Yes.
Well, I had some reservations and still do about whether we should move forward with this, but I'm persuaded by the council's discussion. So I appreciate my colleagues' analysis of this. I think it's going to have to get resolved by the legislature. I don't think this is going to get resolved in court. But if our attorneys want to go get a judge's decision as at least one step in the process of resolving the conflict between the two statutes, then that's a reasonable step to take. Aye. Okay, with the council's permission, I'm going to actually change the order and take up the time certain item because we have a couple of earnest volunteers here whose time is going to be demanded a lot by the city, and they're here this morning using
What
some time
about
again.
47?
So we'll get back to it, but we're going to take item 35 now.
Well, you just run it any way you want.
5, appoint Eli Spivak and Katie Larcell